he was arraigned on the warrant, there were certain bond conditions that were set, one of which was to check in with community corrections and register. He was also to enroll in a drug testing program. Apparently there was some confusion about the community corrections contact portion, but he did enroll in a drug testing program. He was allowed to test in Macomb County where he lives, and but apparently did not.
Who allowed him to test in Macomb?
I'm sorry. I didn't hear you, Judge. I'm sorry.
Who allowed him to test in Macomb?
That was the magistrate indicated that at the time of the arraignment. She said he made a test in Macomb County.
Testing.
He enrolled at a place called Adapt in the city of Warren, and he did.
Do we have any results?
He submitted the one test there. I don't have any results, but I did have verification from the place that he did in fact sign up for testing there. Once it was brought to our attention that he had failed to contact community corrections, he did then call community corrections to try to enroll. They told him because the matter was in warrant status, they couldn't address it. We'd have to deal with the court. He turned himself in for immediately or shortly after finding out about this. He presented himself last week to the jail and was told that he'd have to address the issue today because today was his court date, probable cause conference. So I don't think there was any part on Mr. DeHay's part to not comply. It was just a matter of some confusion on his part about contacting and meeting with community corrections directly. And I think he is 32 years of age. He is working, steadily working. He does have a young child he supports. As I say, he did voluntarily appear both.
Does somebody have the test result where he's testing? He didn't do anything. He didn't go for intake, nothing.
I went to.
He didn't go to corrections, but he did enroll in a testing program, and he did attempt to make an appointment to go to community corrections, but the matter was already in warrant status. So he did appear, as I said, voluntarily, both in November and in December, on learning of this warrant. So he's not. I don't think he's trying to deliberately avoid any responsibility, Your Honor. And if given the opportunity, I do think he would comply. He does have counsel. He is anxious to address this matter. He asked the court to consider reinstating his bond. Thank you.
Landy, before you explode.
Thank
Yes.
you so much, Your Honor. Your Honor, the people are going to request that the court review the bond decision made by the magistrate in this case and find an abuse of discretion. The facts alleged in this case are, first of all, that this is an OWI third offense.
Can I just say, you're saying on the original one? Go ahead.
Yes, the original one, but I understand the bond has been denied right now, but the conditions ordered by the magistrate, the people feel were an abuse of discretion and were not sufficient to ensure public safety. This is an alleged OWI third offense with an alcohol BAC of 0.120, cocaine and THC were also present in the defendant's system. I think if I didn't already say there was a crash, and his priors are from 2017 and 2021. People would request that he have at least intermediate, if not strict supervision from community corrections, as well as an alcohol test in place prior to any release.
Anything else, counsel? I mean, is he in a treatment program? Or is he just testing?
It was just testing. That was all he was ordered to do at the time of the arraignment on November the 27th. And he's working. He supports a young child. He's, as I say, he turned himself in, not only on the original warrant, but he turned himself in voluntarily as soon as he found out that there was a violation. He immediately turned himself in. And the communication that I received from the court was either he has to turn himself in or they'll address it at the time of the probable cause conference, which was today. He turned himself in as soon as he could, which was turned out to be last week, and he's been in jail for the last 6 days. So I don't think there's any attempt on his part to try to avoid his responsibilities here.
Right, but counsel, I'm not clear how we got a PR out of the gate if the allegations are even near true.
Well, he is charged with a OUIL 3. That is true. That was known to the magistrate at the time. We presented information about his background as I've done here today. And the magistrate's the one that set the bond conditions. So I'm not sure. There was nothing unusual about the case, that there was no injury involved in the case. It is still just the 5-year max. So I don't think there was anything that the magistrate was not aware of under the circumstances, certainly from the face of the file or any additional information. As I say, we provided his background information, which I restated here today. So he is employed, and has been for some time, and he has.
Okay, so first of all, let's back up a second. I don't have any results from any testing that he has allegedly done. Let's make that clear. You're telling me that I don't have anything. I mean, from this side, counsel, understand, this looks like he didn't go to community corrections, hasn't tested, hasn't done anything.
Well, I don't disagree with that, except that he did contact community corrections after the matter was in warrant status and attempted to get enrolled with them, and they told him they were not able to process him because the matter was in warrant status. He also voluntarily appeared. He didn't wait till today's date. He came in early to present himself to try to address this situation early, and they said because there was no bond that was issued with the order, that he had to sit there, and has sat there for 6 days. So he has obviously suffered some penalty.
Where are the test results?
Your Honor, I don't have them with me. I
I'll
don't
tell you
have
what,
test results.
before I do anything, because you're just going around in circles, you're telling me all of this stuff, but it doesn't make any sense to me because I don't have any test results. You're telling me he contacted community corrections after he's in bench warrant status. I have someone that's obviously a user. I don't have any testing whatsoever, never reporting to community corrections. In my opinion, that poses a danger to the public because I don't know what he's doing. He's not in any treatment. He's not in anything.
Well,
I'll give him a bond.
Doesn't the file reflect that he was allowed to test in Macomb County? Because she put that on the record, the magistrate did.
But I don't have the results.
I
Follow
understand.
me here.
I
He
understand.
still would have to go to community corrections. He could test then in Macomb County. He has to sign a release. Those results get sent to us. I don't have any of that.
Understood. I'm simply asking, would the court allow him to be discharged, be released on a bond? He can report to community corrections before he's released
Tell
from
you what I'll
jail.
do. Because I honestly, counsel, you're not hearing me, albeit however he's appearing. I'll set his bond at 50,000 cash surety. I'll consider looking at that if somebody can provide me test results and I can set adequate conditions in regard to his supervision. But other than that, I'm not doing anything else.
Your Honor,
Yes, Ms. Lundy.
could the court consider at least a 10% provision on that bond? I mean,
What?
would the court consider at least a 10% provision or something? Maybe.
No. You're just not following this at all.
I'm following that he went from a personal bond to now a $50,000 cash surety bond, and I don't frankly understand. He's voluntarily turned himself in twice on this matter in less than a month's time. And I know the court doesn't have any.
That's the fourth time you've told me that. I get it.
But it's a substantial bond modification. And
Ms. Lundy.
Thank you, Your Honor. If the defendant is released, will that be with a scrim alcohol tether? Be able to
Yes.
post the $50,000 bond? I'm so sorry, I didn't hear the court.
Yes,
Thank you.
it would be with a scram tether and intermediate supervision through community corrections. So what I'll do, in fairness to your client, counsel, because if those results are out there, you can get a document from him to get the results so that I can have the results, and I may consider something else regarding his bond, or I may not. But I'll give you a week to get that. I'll just adjourn this out 1 week to the 26th, and we can see what we can come up with. If I don't have any testing, I'm not changing.
All right, can we schedule this matter for an exam?
Is all discovery complete?
Yes.
I didn't hear your answer.
Yes, it is. I believe it is.
People have their witnesses available in a second.
We'll try, Your Honor.
Preliminary examination in person, January 2nd, 2025 at 12 noon. That's before me.
Thank you. Your Honor, just one more item on this.
I'm sorry?
Sorry, I just had one more question regarding the DeHaze matter.
Sure.
Is the court? Did the
He's
court
not
say,
here anymore. He's been taken back, but go ahead.
okay, procedurally, did the court say it would entertain a request for a bond or review the bond again upon presentment of some information regarding the testing?
I need to see that he's testing. You're
Okay.
telling me he was testing.
Right.
I don't see it.
Thank you. I'll see what I can come up with. Thank you.
We represented ourselves.
All right. Where are we in regard to this case?
So, Your Honor, I filed a motion to dismiss. I'm not sure if that came into your chambers yet.
What's the basis of your motion to dismiss?
The fact that the water bill is what I'm being charged for as non-payment of rent. The water bill is high due to a broken wax ring in the toilet. As per a contractor that Ms. Jelani hired, who stated that this is the cause of the entire problem, and that's never been fixed. That was the first time when the ceiling collapsed, they figured this would happen. So a year later, this was not professionally done. She dismissed this contractor because she didn't want to get it done right. She hired a family friend who did not fix it right. She did not replace the tub or the toilet or fix the wax ring. So because of that, as per his expertise, he stated that.
How much is owing?
I'm sorry?
Your Honor, if I may, these two cases were consolidated. There was originally a non-payment case, and then there is a termination of tenancy case as well. Quite frankly, we're just looking for possession back, and I'd be more than happy to dismiss the non-payment of rent.
There's no lease.
The lease expired in May.
So there's no lease.
We're at a month to month, and I want to leave. I can't leave because work is being done.
Says what?
The work is being done in the home, and there's mold in the home. I put that all in the case that
I understand that, ma'am, but what they want is for you to vacate the premises. And so you're telling me you can't leave because why?
because there's mold in the home and it's not safe to go in. There's no movers who will go in there. I don't want to stay there, but I can't get my stuff out because when we left, everything was just as it was. And it's been that way since August till today. So till today, work is not being done. If you go in there, from what a mover I did send over there saw, it's the floors are missing. They're like, they're not going there. It's not safe.
Your Honor, a little context maybe to help the court. If the court recalls, back in August, there was a loss at the premises. The defendants vacated. The only thing remaining really is their personal possessions. And that's really all we're trying to get is their personal possessions.
And I can definitely do that as long as it's safe to go in for someone. I'm not gonna get sued for.
Well, who said it's unsafe?
A couple of things. There's a sticker on the doors.
What sticker?
There's a sticker.
If I may, Your Honor.
There's a sticker on the door by the fire chief. Do not enter the property unless you're working on it.
Correct.
Right.
Which means that you can enter the premises.
Right. They can enter the premises to do work or to move, but companies are not willing to go in like that. I had one company call before.
This makes no sense to me.
They won't go in.
Disagree, Your Honor. If again, some context, when the loss occurred, they shut off the water because it was a water damage issue. The water and then.
I don't even need to know that.
Okay.
When are you gonna get your stuff out?
As soon as they're done working on the property. Or is
No,
it?
it doesn't work that way.
Okay,
You've got to get your property up.
absolutely, but no one will go in there and take it out because of the status of the home.
Who,
Your Honor, my clients don't even have keys. The only keys.
There's
are
a
in
lockbox on the
the
door.
defendant has.
And she has access to the property.
She doesn't, my client doesn't have any access. We're just trying to get the property back.
And I will gladly give
why
it,
are you guys talking over each other?
I'm sorry.
I have repeatedly requested just a date or a time frame to get stuff out, and I'm still not done.
When there's floors, then people can go in and take stuff out. There's no floors to walk on. And there's
How much property's in there?
a lot, my whole house, my whole life, Your Honor.
So what would you do if I said,
This is a powerful moment. The judge presents a harsh but very real legal option. The belongings could simply be removed and placed outside. Now, legally, that can happen in certain situations. Once possession is granted, the responsibility shifts, and the court can authorize removal. But emotionally, this hits hard. The tenant is talking about her entire life, her belongings, her children's things, everything. And the idea of it being placed outside feels overwhelming. This moment highlights the gap between law and human impact. The law focuses on resolution. The person is dealing with loss. So the question is this a fair solution or too extreme?
they can move it out, put it outside the premises, you got to come get it?
That wouldn't be fair. 'Cause
Pardon? That what?
It wouldn't be fair because
It wouldn't be?
my whole life is in there, Your Honor. I have to pack my stuff, my children's stuff. People just coming in and just taking your stuff out.
But you can't just sit there and not do anything.
I'm not, sir. I'm looking for someone who is willing to go in there and remove my items.
Then what you need to do
Okay.
is I'll pass it, take a break. You need to call. I want to know who you called. Find somebody before you leave here today.
Thank you, Your Honor.
So I have to have my stuff out by today.
What did I just say to you?
He said, find somebody.
You need to call somebody. You can use your phone, look up whoever you got to look up,
Okay.
call them, find somebody that's going to move your stuff and when they can do it.
Okay, thank you. All right, thank you.
And then I'll call the case back up, but don't leave the building until such time as I tell you you can leave, because we're gonna get a date today. And that was fun. Okay. Go ahead.
So I called several companies and they posed a very valid question that I forgot to bring up. Where will you be taking your items to now? I don't have any place to take it because I'm displaced because of the landlord's negligence to fix the housing, the ceiling collapse. So I'm in a hotel with 4 children. I have nowhere to take it. That's one thing. I need time to find a place. I've been looking since May and even more now in August, and nobody wants to rent with me because they're like, you know, you have an eviction. So I did ask though. I said, well, if I had to move the stuff, could you come? There's mold present. 2 men in a truck said, no, they're not doing it. I can call, put Debbie on the speaker. This side up moving said, absolutely not. That's via text because of the mold present. A third party, he says, he has to see how bad it is, but with mold, he can't send his guides in there.
If I may, Your Honor, my client would be happy to give 30 days to get their stuff out, and after that, the writ would issue. There's some other options we can put on the table here to get this over and done with.
I need to be able to find a place to stay. I can try. I don't know.
Okay, so here's the problem. You got to find a place.
Yeah, I've been trying. Right?
No, you got to find a place.
I
Because if you can't find a place, so understand what will happen.
okay.
What will happen is I will set this for trial. If you lose that trial, it's not gonna, all of these questions aren't gonna matter, because what will happen is I'll give them the authority just to put it out on the curb.
Your Honor, I need more time than 30 days to get out of there. It's not like I don't want to be there. I need to find. I don't want to go to trial. I really don't. I want to be done with it, but I need to find a place that rents. If there's given to me by.
Have you asked them how much time they'll get? They're saying 30 days. Have you proposed anything to them about time frame?
Yeah, I've told this to Mr. Evanchik. I've told him that what's going on. I've been in conversation with him. He's just telling me, get out, get out, get out.
Okay, fine.
I-
But if he's saying 30 days, have you given him a time frame that you could do it?
He never said 30 days, but I cannot.
Okay, he just said 30 days. Do you have a time frame that you could do it?
I might need 90 days because there's an eviction. If the eviction can go away and I can get something from the court showing prospective landlords that I'm not on eviction, I'm not being evicted, I was never evicted, they will rent to me. My credit is fine. It's not the issue. It's just this fact. I didn't want to spend Thanksgiving in a hotel with my 4 kids or Christmas or their birthdays.
30 days conditional order dismissal
30 days is not enough.
with the reinstatement in the event that
Your Honor, excuse me, Your Honor, can I speak, please, if you don't mind?
Sure.
Okay, Miss Janet Garden has been staying with us. The biggest problem out of this whole issue is the kids that are involved. And they came out of their house. My nephew was the ceiling fell, almost killed him. She just lost that. She lost one of her child during COVID. So it's been like an emotional roller coaster, a single mom with 4 kids. She's been paying our rent to this, the landlord. I've been helping out this family. And it's just to see when things happen and there's a crisis. Within those crisis time, everything everyone wants in the society is money, 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 money. Not forgetting the people that has been displaced in this situation.
Ma'am,
They didn't
that's
really
not true
know.
here
Unless
because they
they-
said, ma'am, that's not true here because they said that
The
they
guy's
just
been
want
so
the premises.
aggressive.
Wait, let me talk.
The guy's been
Wait,
very
let-
aggressive. Okay.
What do you guys want to do?
I need more time. I will leave the premise.
Then what I'm gonna do is I'm gonna send you out there, talk to Mr. Evercheck. You guys try to figure out a time.
He's very aggressive,
Your
sir.
Honor,
He's very
Miss,
aggressive.
hold on.
All right, then you're gonna need to talk to me.
Yes.
If
Your
you
Honor.
want the bottom line of aggressiveness, you're gonna have to talk to me.
Yes.
So I'm gonna pass the matter. Have a seat.
Yes, sir.
Okay, folks. So we are not any further along than when I last left you, I'm presuming.
No, Your Honor, I did try to discuss this with, not successful.
And ma'am, what is there's no lease.
No.
So I guess the question becomes, why wouldn't I
Now the pressure
and give you 10 days to move?
Well, because there was conversation of continuation of a lease prior to this collapse. And if it wasn't for the collapse, I probably would have at this point found a place to stay. And I would not be in a hotel spending thousands of dollars. And we wouldn't be here at all. And there would be no eviction. And I would have been able to get a new place smoothly and have my family safe and happy.
But you understand that I really don't, other than maybe a few equities that fall to your side, have a reason to delay it. I mean, here's the reality of it. The reality is you're gonna need to move,
Yes.
all right? So from my standpoint, it's the issue of time. And you're saying you need 90 days.
At least, sir.
Well, that's not gonna happen. I mean, I can tell you, I'm not gonna issue a judgment for 90 days. Is rent being paid?
No, because the property is not habitable.
Got it.
There is rent and escrow from when this originally started as a non-payment, paid $2,500, so we would ask that be my client.
No. If it wasn't for the landlord's negligence, we wouldn't be here to begin with.
Okay, well, I can solve the escrow issue right now. I'm not returning it to anybody right at this moment. Okay. Because the issue is a move out.
All right, so how much time can you allot me, Your Honor? Because, I mean, there'll be another case with the situation of the housing and all, but right now they want possession. So what's the max amount of time you can give me, knowing that no one is willing to come and move my property? And also knowing that I cannot find a new place within the state of Michigan with the open eviction under my name?
Well, let me answer it this way. I try to resolve these in a fashion where it is beneficial for both parties. All right. And let me ask you this. Would you be able to get this all arranged in 30 days?
No, sir.
All right.
I can, if you will allow me maybe 60 days, that would be more. If I can also get some from the court or the landlord stating that I'm not evicted. So when I do present my application to new housing, I can present that as well.
And Your Honor, if I may, as we previously indicated, we're happy to do a conditional order dismissal to move this along.
Your Honor, how long does an eviction stay within your court, please? Because they do check that.
What do you mean? How long does it stay?
Like if a prospective landlord's realtor is looking at my name or pulling up records to see.
What if they pull it up and they look at it? And what counsel's indicating is if we do this by way of a conditional order of dismissal, then it will look as though the case is dismissed.
Okay.
And then otherwise, it's going to look like there's a judgment or a pending action.
Right. Okay.
If they come in, I will say this, if they come in and look closely at the file, they may see something different,
Oh,
but it will reflect as a conditional order of dismissal. It'll look as though it's dismissed. If you comply with all of the terms and plaintiff doesn't have to then issue the judgment and have you evicted, it will look as though it is dismissed.
okay. I don't know how that's gonna help me or hurt me, but what I would like to ask is, did you get a moment to look at my motion to dismiss? Can we just dismiss it all altogether, being that?
The motion to dismiss is denied. There isn't a basis for me to dismiss the case. In
Okay,
particular, not the termination action.
I'm sorry.
In particular, not the termination action.
Okay, so the eviction is based on $200 that I did not pay for her to fix the plumbing because the plumbing was never fixed. Until the time that
Ma'am, if you want to litigate this case, then you can litigate it. And you're gonna be right at that 10-day period. But if you want to go ahead, you can go ahead.
Well, no, I don't want to be at a 10-day period. I would like to have time to get a company who's willing to move my stuff out with the mold situation.
All right, here's what I would suggest to the parties.
Okay.
That there be a conditional order of dismissal with that the defendant would vacate the premises by January 31st of 2025.
I apologize, Your Honor, I'm not doing the math, but is that more than 56 days?
It is not.
Okay, so we're under 56.
Yes,
I think that works out to pretty close to 45 days.
correct. So about,
My client's fine with that.
what about you?
Okay, t-shirt. Can I get something next week? I'm sorry, Your Honor, you said.
The January 31st date. Okay. Now, I think in the conditional order dismissal would have to acknowledge that you are not residing in the premises, but that there and won't reside in the premises.
Sorry, I can't hear you.
That the conditional order dismissal would have to indicate that you're not residing in the premises, will not reside in the premises, but that you have personal property in the or on the property,
Okay,
and that the personal property would have to be removed by defendant prior to that date.
okay,
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 just so that we make that clear. All right. Also, in the conditional order dismissal, the amount held in escrow, that the court will rule on that issue after the defendant has vacated the premises
Okay.
as to where that property would go or where that money would go. And I can give a court date for you guys to come back. I need a court date in February. And that there's a hearing set on the escrow for February 4th, 2025 at 9 a.m.
Do we have to be here in person, Your Honor?
You'd have to submit a form to appear in Zoom.
I'm sorry, sir.
You'd have to submit a form if you're going to appear by Zoom. I'm not guaranteeing that I would say that you can.
Okay.
If you have if everything is out of the property, I'm going to be much more inclined to let that happen.
Sounds good to me.
Thank you.
One more thing. In regards to the mold and everybody denying me to come in because of the mold, is it possible for you to put into the conditional that they can at least show something that the mold has been taken care of? So, because people are gonna have to come in and pack my stuff, so they're comfortable doing.
Well, I'm not going to get into that. I will just say this,
Okay.
that mold can appear there's mold everywhere. The question is whether or not the mold is of a type and nature that exposure to that would jeopardize some impairment of human health.
It is.
I don't know that, ma'am.
No, I sent you the mold report.
I understand that, but there are differences there are still differences in that. So I am not going to, I'm not here to make a ruling and will not make a ruling as it regards the mold and the like. If the folks that move in go in to move your property have to mask up or do whatever it needs to protect themselves, and they certainly can do that.
Okay.
Because if you don't move the property, the reality is that's precisely what plaintiff is going to have to do in regard to getting the property out of the premises. So, all right. Anything else?
No, if I could just read back through this really quick, Your Honor.
Yes.
And I'm going to be preparing this.
Yes.
So, defendant to vacate on or before January 31st by removing personal property possession. Defendants have already vacated the premises. The court will be on 4th, 2025 at 9 o'clock in regards to $2,500 that escrowed. I assume that if we are able to reach resolution ahead of that, then we don't need to come back.
Correct.
Okay, so I will draft this up and submit it to the court, or a copy of what post at the time.
All right. Very good.
Thank you, Your Honor.
Do either of you have any other questions?
No, that'll be all.
All right. Thank
Have a
you.
happy holiday.
Have a wonderful holiday, sir.
You do the same.
Court does call the case of Tortora versus Martin Yance.
Good afternoon, Your Honor. May it please the court, Eric Ladavsky, 65354 on behalf of plaintiff.
Good afternoon, Your Honor. Darwin Fair on behalf of the Yances.
All right. Where are we now on this one, folks?
Your Honor, to refresh your memory, I filed the motion, which was first heard on October 11th of this year. And of that morning of that date, Mr. Fair had filed a motion in the circuit court. And so this court adjourned it to November 1st. The motion was not heard yet. Now, the motions that were in front of Judge Jewell in the Wayne County Circuit Court have been disposed of. And there is now in this court for this specific property, the circuit court action in Washington County Court has been dismissed. Mr. Fair appealed. That appeal has been dismissed as well.
Is that correct?
No.
Here we go. Okay, what's not correct about it?
Judge,
I guess counsel's indicating to me there's nothing else pending except.
Judge, I filed my motion in front of the Wayne County Circuit Court judge that you are aware of, that occurred the last time we were in court. There's been no change in that case today. No change. It is still before the judge.
Right, correct?
The Register of Actions had the hearing on both motions in front of Judge Jewell. There was nothing pending. There's no pending motions in front of Judge Jewell right now. I had the Register of Actions.
But does it say something about what happened with the motions? Or
I filed the motion for enforcing the judgment that was dismissed. Mr. Fair filed the motion to enforce the settlement agreement as well. And I do have the order if the judge, if Your Honor would like to see it. And in that order, it sent us back to Judge Hattie.
sent you back to who?
Judge Hattie as a mediator, which has been unsuccessful.
So there hasn't been so there actually hasn't been, it hasn't been disposed of.
No, it has not been disposed of, Judge.
But there's no pending motion either.
Yes, there is a pending motion because it's before Judge Hattie. And Judge Hattie hasn't concluded.
Oh,
the case.
let's quit playing semantics with this. Is there still a court proceeding going on?
Yes.
The court needs to enter a dismissal in Wayne County. There is no pending motion. The court indicates the case is closed, but there has not been a final order because the dismissal has not been signed yet.
No, Judge, that's not true. I filed my motion to reopen the case and to have the case remanded to Judge Hattie for mediation. That's where the case is right now. It's before Judge Hattie, who then, if and when he finishes his mediation, will do a final order to the circuit court judge, which has not occurred yet.
That's what it sounds like to me. Right, counsel?
That
was a question.
I didn't understand your question.
The order sent it back to the mediator that somehow either is going to give some recommendation or something to the Wayne County judge by which an order will then happen.
No, Your Honor, the mediator's been unsuccessful. There's no order that orders the mediator to submit an order. Which is what Mr.
That doesn't
Fair
make any
now
sense, counsel. And I'll tell you, I'm getting a little bit tired right now because, and I don't want to play semantic games here. There is no motion pending. I get that. Part of the decision, or at least temporary disposition of that motion, was it sent it to a mediator, Judge Hattie, right?
Correct.
Judge Hattie, while you may look at mediation as having been unsuccessful, has mediation concluded?
Yes. We're
No, it has not concluded.
How do two people share a case and have no idea what's actually procedurally happening? Is there another date that's set before Judge Hattie?
No.
Mr. Fair.
He is waiting to see if we can settle so that he can do a final.
Okay, look, you know what, guys? Every time you come here, everybody just starts saying the sky's blue. The other one says it's orange. The other one's, and I'm getting sick and tired of it. I don't think that the questions I'm asking, where the posture or procedure is in a case, is a very difficult thing for counsel to ever agree on. But for whatever reason, you guys can't. I think you're being disingenuous, counsel, when you tell me that there's nothing pending. I asked you if there's anything pending. You're telling me there's no motion. That wasn't my question. Then, when I'm asking, is mediation been concluded? You're telling me yes, but there's no order.
And here comes
Concluding it, but the judge sent it to mediation. So here's what's going to happen. So what's going to happen is I'm going to adjourn this matter. What is it, January 10th?
Yes, sir.
January 10th, 2025 at 2 p.m. Realize that he is retired now. but I need a letter or communication from Judge Hattie as to the status of mediation.
Thanks, Your Honor.
If I don't get that, just don't even bother showing up, either one of you.
Thanks, Your Honor.
Thank you, Your Honor.
Town Center Place versus Jacqueline King. Patterson.
Good afternoon, Your Honor. Toy Dennis on behalf of Ms. King.
Good afternoon, Your Honor. Jackie Snyder Powder on behalf of Mark Wasbury.
Oh,
Your,
this is your baby.
This is my new one.
That's your new one?
Yeah.
How old?
He is only 3 months old, and I apologize, Your Honor. My husband's getting our other son off the bus, so.
No, you do not have to apologize if you bring a baby. And you win. Okay.
Thank you.
Thanks, Miss Dennis. No.
well,
mean-
I think we do win, Your Honor, because we can make this quick.
Okay.
As far as I know, Mr. Wasbury agreed to a 10-day adjournment. We're still exchanging information.
So
he
you're just
provided
looking
me
for a new
some-
date?
Yes, Your Honor.
Yes.
All right. Will the 27th work?
Yes, Your Honor.
All right. I'll adjourn this matter to
Yes, Your
December 27th, 2024 at 1 p.m. and make a special note that you need to bring the baby. All right.
Okay, I will.
All right.
Thank you, Your
Okay,
Honor.
guys. Thank you. Have a
Thank
great
you, Your
weekend.
Honor. You too.
You too. Happy holiday.
Thank you.
Yes, and to you.